Our commentator is Dr. Ido Shahar from the Department of Middle Eastern History at Haifa University. Ido is a legal anthropologist and a social historian. He specializes in the study of Islamic law and in particular in the study of Sharia courts. His book, Legal Pluralism in the Holy City, Competing Courts, Forum Shopping, and Institutional Dynamics in Jerusalem, provides a portrayal of a Sharia court in contemporary West Jerusalem, which belongs to the Israeli legal system but serves Palestinian residents of the eastern part of the city.
You should explain why you stand, so people don't think.
It's my back. That's fine.
I can speak from here. Okay? Okay. Yeah, sure. Good afternoon. Thank you very much for inviting me to participate in this workshop and to comment on two very interesting papers. I must say, for me, it's a treat to respond to two papers about legal pluralism which do not deal with family law and personal status. So I'm thankful. Now, unfortunately, I know very little about tax systems, and even less on dealing with mass torts in Japan or elsewhere for that purpose. So since I don't have much to say about the subject matter of the articles, I will focus in my brief comments on conceptual issues and on legal pluralist the legal pluralist perspective that you both employed, a topic I feel more confident talking about. So I enjoyed reading both papers. I find them interesting, illuminating, rich, and very compelling in their application of a legal pluralist approach. Both papers deal, as we have heard, with challenging issues. The Fukushima case in particular is challenging because it's not easy to study a matter which is very much ongoing, very much still under process, at least from a social scientific perspective. This is an ambitious task that you took upon yourself, so very brave. Similarly, a research into the history of the tax system in Israel is also challenging, both because it is an uncharted territory and because it requires, I suspect, a research paradigm which goes beyond the legal sphere and which touches upon political and economic history as well. Given these challenges, and given that both papers are obviously work-in-progress drafts, it is not surprising, perhaps, that they are, in a way, more descriptive in nature than interpretive. Morit's paper describes the complex plurilegal arrangements that developed in Japan in the context of the emergent need to compensate a huge number of victims following the Fukushima nuclear plant disaster in 2011. Sav's paper describes voluntary tax collections institutions that operated in Jewish Yishuv before the establishment of the State of Israel, as well as public voluntary institutions that operated in the domain of tax collection during the first decades of the state. So we just heard the presentation. Both articles thus constitute sort of preliminary attempts to tackle very different subject matters by using the framework of legal pluralism. In my view, this is a very promising endeavor which calls for a further elaboration of this conceptual framework. Now, it's not that I am looking for an elaborate plurilegal theorization. I don't see legal pluralism as a theoretical tool in itself. It is, to quote the late Franz von Bender-Beckmann, a sensitizing concept. A concept or a perspective which draws our attention to the multiplicity of normative orders, to the dual presence of state and non-state mechanisms of dispute resolution, and to the interrelations of these mechanisms and these normative orders. I feel, however, that in both cases, legal pluralism as a sensitizing concept may and should be taken further. In my view, the cases of mass tort compensation in Japan and of the Israeli tax system practically invite a plurilegal analysis of the complex manner in which the various state and non-state mechanisms interact and influence one another. How does the Japanese judiciary, for example, respond to the compensation schemes developed by the Nuclear Damage Dispute Resolution Center? Do they refer in their judgment to these schemes? Do they relate to failed attempts to reach a compensation agreement out of court? On the other hand, how does the judicial compensation policy issued by the state courts influence direct negotiations between victims and the representatives of the plant operator? How does it influence the mode of operation of the center? So it's not enough just to characterize the type of relations between these mechanisms as competitive or collaborative or complementary. One needs also to deal with the impact they have on each other. So similarly, how did the British mandate authorities and the mandate legal system respond to the Jewish communal tax system? As noted by Asaf, the British authorities debated this matter and decided already in 1939 not to intervene. But surely there had to be cases of institutional and legal intersections. There had to be cases in which, for example, an unhappy Jewish taxpayer who was required to pay his or her voluntary tax to the community complained about threats or even extortion. There had to be cases in which a threat or a complaint, a threat to complain to the mandate authority was brought about by unhappy taxpayers who felt they were pressurized in an illegal manner. There had to be real cases in which the Jewish communal tax collection was dealt with by the mandate legal system. In other words, there had to be cases or situations or moments in which the statal colonial system and the communal system interact. My point is, therefore, that a legal pluralist perspective should not settle for just describing the multiplicity of normative orders or the multiplicity of dispute resolution institutions in a certain social field. Such a perspective must assume, in my view, that these normative orders / mechanisms of dispute resolution are interrelated to each other. They influence one another. They relate to one another in intricate ways. Indeed, we may even say that they shape and constitute one another. Thus, rather than treating the coexisting normative order / mechanisms of dispute resolutions as separated, well-defined, and self-contained, as if they exist in a bubble detached from one another, the sensitizing concept of legal pluralism should draw our attention to the relations between them and to the manner by which they constitute one another. I'm advocating here what I call a relational approach to legal pluralism, which I believe may prove particularly beneficial in both your articles. Such an approach may focus, in addition to the constitutive interrelations between normative orders, also on the way actors or agents respond to the coexistence of these orders. How do they, that is actors, how do they conduct themselves in such circumstances? How, if at all, do they maneuver between these orders? How, if at all, do they manipulate the system and take advantage of the choice of forum open to them? And what impact, if at all, do the accumulative choices of actors bear on mechanisms of dispute resolution? In my humble view, this would be a very promising avenue for both your papers. And since not so many legal pluralist scholars follow this line of research, you may also make an important contribution to the general field of legal pluralism. Well, this is just a suggestion, so hope you find it useful. So.
Thank you so much.